Finally, we take up the question of Islamic legal procedure. Now, when we were talking about the law, we talked about how important enforcement of the law was. Enforcement is what gives the law meaning. So whenever we look at the law, resolving a dispute according to the law, we have to look at what is the substance of the law, what does the law actually say, and then we also have to look at how do we enforce the law. What is the legal procedure like? And it turns out that procedure can actually shape the law. So when we talk about Islamic legal procedure, we find that rules regarding procedure can actually shape what is the law. So every law has these two aspects. For every law, there's a right contained within the law, and there's a remedy if the right is not granted. So for every law, there's a right and a remedy. And the remedy requires a means of enforcing the law. The remedy is what gives the law meaning. And we enforce the law through a series of legal procedures. And these legal procedures are found in the legal system. Now, legal procedure can affect legal substance. It turns out that legal procedure, how we resolve dispute, can influence what the law is or is not. The law can evolve in light of the procedure used to enforce the law. The best example of this, is we're going to get to it in a minute, is the idea of whether the words of the contract are important or not. In the case of a breach of contract, in the common law, it is very important that the contract be carefully drafted, because if there's a contract, then that is the defining terms of the deal. In a written contract controls the resolution of any dispute according to that contract. When it comes to Islamic law, the most important thing is testimony. And therefore, we look to the testimony of the parties as to what they believe the contract meant, not to the specific words that were used. So, but because of those procedural decisions, what that means is that in common law systems, we tend to have contracts that are very lengthy and very detailed, because in a court of law, when we're trying to enforce the terms of the contract, the court can only look to the written terms of the contract. In an Islamic law, you want to draft a contract that's very broad and open-ended, because if there's a dispute, you want to be able to have the court look to the testimony of the parties. Now, legal procedure in Islamic countries differs from Western legal systems. Traditionally, Sharia courts do not rely on lawyers. People represent themselves. Plaintiffs and defendants represent themselves. And as I pointed out, Sharia law is left to the interpretation of the judge in each case, and there's no formally codified universal statutes. Now, in Islamic country, trials are conducted solely by the judge. There's no jury system to speak of in Sharia law. There's no pretrial discovery process and no cross-examination of witnesses. And again, I'm going to prepare a separate lecture comparing procedure across the legal systems. Unlike common law, judges' verdicts do not set binding precedents. The principle of stare decisis is not present in Islamic systems. Every case is a brand new case. No judge is bound by what another court has said should be the resolution. The rules of evidence in Sharia courts maintain a custom of prioritizing oral testimony, meaning written evidence can be important, but oaths, oral testimony given under oath, are of much greater weight. The court wants to hear from the parties themselves, not through lawyers, and they want to hear what the parties themselves say as to the meaning of a contract, for instance. In fact, an oath is so important in Sharia law systems that the oath itself can be used as evidence. not simply a guarantee that the evidence is true, but the oath itself, the fact that you are willing to take an oath, is evidence of the veracity of your case. So oaths are important in the common law system as well, and the civil law system, but not nearly as important as they are in the Sharia law system. In fact, if a plaintiff brings a case and has no other evidence other than his oath, and the defendant does not swear under an oath to his evidence, then the plaintiff will win, because the oath is strong evidence of the truth of what's being maintained. So even if you don't have any other evidence to support your claim, you can demand that the defendants take an oath in order to establish their innocence. And if in fact they refuse, that can result in a verdict for the plaintiff. Now, Sharia judges and scholars are limited, and they're limited because of the nature of Sharia law, that it's already set down. We cannot change or modify or extend that law. The law is already fixed, that if what Muhammad said or what the Quran said as dictated to Muhammad, if that was the law when it was created, that's the law today. Nothing can change the Word of God. God can be the only thing that can change that. So jurists and scholars cannot change or modify or extend the law. And what that means is that sometimes Sharia law is a legal system that doesn't comport with the modern world. That there may be bounds, rules in Sharia that do not match up with the modern world, the modern economic system, for instance. And that's what this case is about, this Khaki versus Hashim case. Now, this is a very, very long opinion, so I put a link on D2L to show to some cases discussing this case. But at the heart of this case was really the question of, can Sharia law render interest, the collection of interest, as illegal? Now, you know that in the world's legal systems, or in the world's economic systems, interest is very commonplace, that you borrow money, you borrow capital, and you use that capital to invest in your business, and the business makes money, theoretically, and you use that money in part to pay off the loan plus interest. So there's a charge associated with the use of that money, and that's interest. Well, historically, interest was seen as sinful. The charging of interest is something that in cultures around the world was seen as wrong. And it is that case in Islamic countries. The collection of interest is called riba, R-I-B-A. And riba is illegal. The belief is that you should not use money to make money, that you should make money using your own abilities, your own sweat. You should not make money using money. And so Islamic law is pretty clear cut that riba is illegal. Well, in this case, which was in Pakistan, a court had to decide, could a Pakistani bank charge interest on a loan, even if that loan was to a non-Muslim? And in a very long, detailed opinion, the court said, no, they can't. It's illegal. Now, riba, the collection of interest, is illegal regardless of how the modern world works, because the Quran says you can't collect interest. Now, the court was also clear in saying there are other means of accomplishing the same thing. For instance, you could have a joint venture agreement in which the borrower comes to the financial institution and asks to borrow money, and in exchange gives to the financial institution an interest in the business. If the business does good, if it makes money, then the bank makes money. But if the business does bad, the bank does bad. So these joint venture agreements can serve the same function as interest, but what they do is they make the bank a partner in the underlying enterprise. And many would argue that that maybe be a better system. Whereas here in the West, we charge interest and the bank really doesn't care about whether the underlying business succeeds or fails because they're going to make money off of the interest. Or if they care relatively little. So this case is a great example of how Sharia law interacts with the modern world, can be problematic, but can also provide a solution. So in conclusion, what did we learn today? Islamic law is the principal source of law in many predominantly Muslim countries. Sharia law is derived from 4 sources, and we learned a little bit about Islamic legal procedure. Thanks.